Thanks, Senator. Questions from committee members? Senator Grothman.
Okay, apparently the alleged council member was talking about what you're talking about. Doesn't flat out say it's unconstitutional, but it raises significant constitutional concern.
I would be surprised if somebody doesn't file a court case, but based upon what I see, I think they're going to lose their case.
Okay, and there's also something introduced into the bill draft that it's a response to the legislative council memo. Do you know who submitted this?
I'm sorry.
The name was cut off. No, the name was, it's part of the bill draft.
Probably the one who physically gave it to him, Mike, and I will let you know by the end of the day where that is. But
There isn't a rule that there must be an attribution.
Okay. Because the question I got is whether or not whoever submitted this, I'm assuming it's a lawyer.
looks like something a lawyer would.
Yeah,
Yeah.
whether or not the lawyer or the lawyer's law firm is involved at all in any of the defense of what we're dealing with here.
I don't know that either. We'll find that out. Like I said, I'm not sure who came up with that. Like always, sometimes when people assist us in things, and I will find out who drafted that thing. As a matter of fact, I don't know if I just have a copy of that. If you want to have the page down, take a copy of it. I
Part of the
will.
bill.
Pardon?
Part of the bill draft. If I can, exactly how far back did this go? Did the legislation pass that bill?
How far back?
Retroactivity, how far back did it go?
Well, I don't know recently whether there have been any other cases in which companies are suing for products made over 100 years ago, but it applies to products made over 100 years ago.
Any product that over 100 years ago?
Right, I mean, it's kind of bizarre. It's one of the bizarre things in this case, outside of the purview of the bill, the idea that, think about that. You could make a product in 2011, 2012 is now, and you could be sued for what you made in 2012. You could be sued in 2130. You would make a product if that could happen.
Don't you think the courts would take all of that into consideration?
Well, this is a very bizarre court decision. I mean, as Senator Zipper said, we're the only court in the country to reach such a strange conclusion. So I hope in the future we don't have dramatic changes in the law 120 years after we make the product. Okay, Senator.
Yeah. You talk about being against retroactivity, but this bill creates retroactivity, doesn't it?
No. It creates retroactivity as far as, I wouldn't say retroactivity, it changes procedurally how you handle a lawsuit. There's nobody in this room who, if they can show that a company produced paint and that company, as I understand it,
No, I just talking about the retroactivity. Let me wait. Doesn't this change the rules after the game is started? This isn't fair. You're changing the rules after the game is started. There's lawsuits pending, and you're saying, well, those lawsuits pending, you're going to change the rules.
or a procedural thing. It's like if
Well, that's procedural.
it's like you change a judge halfway through a court case, which could happen. I mean, that doesn't mean that, it doesn't mean that you lost your right to something. I mean, if you can show that the ABC company put paint in some house and should have known better.
Oh, wait a minute, aren't you changing the rules after the game is started? I'm a lawyer, you're a lawyer. We get into court, we set up a case to try the jury and have...
You're changing the rules, but not the rights. I'll put it that way. You're changing the rules, but not the rights.
The rules, the rights, they're changing.
No, they're very different things. They're very different things.
I mean, there's a difference between rules and rights.
We're changing a rule, but we're not changing a right. Right, you still have the right or the ownership or whatever, to collect X amount of money and to file a lawsuit from X company. But we're changing the idea where you can put all these different companies on the hook.
Senator, you and I are lawyers. I'm saying you prepare a case for trial. You get ready to introduce witnesses, you get you're ready to go to court, and then all of a sudden, they say, we're changing the procedure, you're changing the rules. Is that fair?
Yeah, when the old rules are bad. I'll give you an example, Senator.
Dominique.
When the court changed this, when the court changed what anybody ever would have dreamed, this contribution liability, risk contribution liability theory, that was a huge change for companies that were not public. And that was just a horrible decision. In addition to being an outlier decision, nobody got enough of it. After the fact, a company that, thought they had no liability under the sun, all of a sudden a liability only for the small amount of paint they produce is on the hook for everything. And that was a horrible court decision. In addition, it was a morally repugnant decision, which was retroactively applying liability. This, all you're doing is changing what amounts to almost a step above procedural rules in court. I mean, that doesn't change the fact that you can file a court case if you can show a child was dangerous, if you can show that this company produced the pain, if you can show that this pain caused the child to suffer some health problems. You can still do all those things.
Isn't it possible that when you change the rules, that you in effect make moot the case that's in court?
Be quiet now.
Well, I guess that would be up to any individual attorney to explain to his clients.
All right, so aren't we in effect, not only are we changing the rules, aren't we in effect saying that we are possibly making moot the case that's in court?
I don't know. I mean, I suppose you could say.
But that's not fair.
Well, I think this whole bill is about fairness. You mean to tell me that if there was a paint company that was in existence in 1900,
I'm talking about
and that paint company,
Please let Senator Grothman
and that
answer the
paint
question.
company's been bankrupt for 70 years, and all the time we find cases in which there's an injury and that person is judgment-proof or whatever. So all of a sudden we come up with this new cockamamie theory of law, and some other paint company has got to pay the liabilities for a paint company that's been bankrupt for 70 years. I mean, that is the most absurd, unethical thing I can imagine. And that's what you're going to defend.
I think, did you want to ask a follow-up, Senator Urban?
Yeah, a couple of, just picking up on what Fred's talking about. And again, I'm not a lawyer, you are. Neil, you're not a lawyer, right? Okay, all right, I'm gonna go sit on that side of the table. I'm having a hard time understanding, perhaps because I'm not a lawyer, with the rules and the rights. You go to court, these are the rules and the rights, these are the rules you have to abide by, these are the rights that the defendant, the complainant have, that's what you have to play by. This legislation appears to come in and change things dramatically. So to put it in terms that I understand, let's say there's a football game between the Packers and the Giants. And you go over the rules beforehand, you flip the coin, you kick the ball off. And New York, because it's New York, doesn't like the rules because the Packers might be winning, so they're able to change the rules halfway through the game. How do you expect the game to move forward? How do you expect this to move forward when cases are being built on what the law currently is? It's like going back and changing the rules for anything, once it's in statute or once it's in place. How is that supposed to work?
Well, it's going to work very simply.
How?
You're going to adjust to this change in the law.
Or throw the cases out because they don't have merit anymore.
Oh, they're going to have the same merit they always had. They're going to have the same merit in this if you can prove damages, if you can prove that a company should have known about those, as I understand it, known that their product could cause damages, you can still try to sue that company.
Okay. All right, and then the other thing, I want to get back to this memo, because obviously what Ledge Council has to say to all of us in memos, we cherish. We really value what they have to say.
Well,
So there seems to be...
I respect them, I don't share.
All right, so there seems to be...
You're not going to be polite, by the way.
It would seem to me that trying to find out where this particular piece of paper came that was submitted into the file
We'll track that
is
down.
extremely important, so I would hope, I don't want the...
We got all day to find it.
I would hope-
My Lance is around here, but somewhere, if he's listening downstairs, we'll find out.
I would hope, Mr. Chairman, that before the end of the day, before this committee hearing is done, we can find out where this came from, because it's extremely important. Because if it came from just some unbiased lawyer or law firm out there that doesn't have a stake in this case one way or the other, that's one thing. But if it came from a law firm that is representing a defendant or could be representing a defendant, that's a whole nother thing. And it's submitted into the bill jacket, which, again, without a name, is I've never seen it before. So I would hope that by the end of the committee hearing, we'll find out where it came from.
I hope so. Now, just so I can help you, I'm going to make a copy of that. I read it to you guys, but I just want to see what you're referring to. Just there briefly. So why don't we, I think so.